If your estate planning considers only money, taxes, and legal documents, you're missing out. Discuss your intentions and purposes with the attorney who is drafting your estate plan, so that the words written in your power of attorney document prevent future problems.
The drafting attorney himself understood that the class of potential donees would include the decedent's children, would include Chris and Tony themselves. If that were the drafting attorney's understanding and construction of the gifting authority in this power of attorney, so too is it reasonable to conclude that it was Frances Fern's understanding as well.
30 years ago, a Massachusetts court case declared that self-dealing by an agent in the absence of distinct authority from the principal that is expressly granted in the empowering instrument has been continuously and uniformly denounced as one of the most profound breaches of fiduciary duty. Tracy argued that the gifting language in Frances's power of attorney was not sufficiently distinct to authorize the gifts. But the court decided that the language Frances actually used here, persons who, in the opinion of my said attorney, would be the donees I may choose, was sufficient to authorize gifts to Tony and Chris, since Tony and Chris were Frances's immediate family members.
I do think that the testimony of Attorney Ward, the drafting attorney, was critical. He confirmed that the language included in the power of attorney was the standard gifting power that he uses. He confirmed that his practice was to include that language if there may be tax issues involved with one of his clients, so that if there is an opportunity to make gifts, then we want to have that ability.
This court accepted the future decision-making power granted to Tony and Chris in the power of attorney as good enough to make the gifts. But while this was accepted by this court in this case, power of attorney documents that do not specifically say that your agent has the power to make gifts to himself have been rejected by real estate title insurance companies. Without explicit self-dealing language, title companies and title examiners may not insure or certify real estate that is transferred to a person who is also the agent named in the power of attorney. If we use specific language authorizing gifts in the power of attorney, we remove any doubt that you understood and intended to allow gifts to your agent under the power of attorney.